Today's mystery is, when does a defendant's DNA on a gun not prove he illegally possessed it? How's it going? This is Alex Zouzlas, author of the book Courtroom Confidential. Today's mystery is, when is it not possible to prove a convicted felon illegally possessed a gun even though his DNA is on the gun? The key to solving the mystery is asking, when did the defendant touch the gun? Which is a second mystery, but one the prosecution can never solve. Just a reminder, I'm not giving legal advice, just analyzing a mysterious situation and showing how I solved it a couple of years ago. So let's look at the facts of the case. The defendant, whom I'll call Forrest, was charged with several felonies, including possession of a firearm and ammunition by a convicted felon. Forrest, who you can tell is a convicted felon because he was charged with possession of a firearm by a convicted felon, was driving in Chinatown when he was stopped by Detective Getty because of a window tint violation, which is a legitimate reason for a traffic stop. Detective Getty tells Forrest to get out of his car and walk toward him. So, Forrest gets out of his car and walks toward Getty. The whole time, Forrest's putting his hands in and out of the pockets of his jeans, which makes Getty very suspicious. While another cop keeps an eye on Forrest, Getty checks Forrest's driver's license and finds out it's suspended. So he arrests Forrest, and when he searches him, incident to that arrest, Getty finds over $9,500 in cash and several phones. At this point, Getty's thinking there's drugs in Forrest's car. If he wants to, he can search Forrest's car either incident to Forrest's arrest or to inventory the contents of the car. But Getty doesn't do that. Instead, Scout gets involved. Who's Scout? Scout's the drug-sniffing dog sitting in Getty's patrol car. Getty grabs Scout. Scout walks around Forrest's car. Scout alerts to Forrest's car, which convinces Getty there's drugs in the car. And there are, but there's something else in there. No, it's not Forrest's mother-in-law. It's a pistol and ammunition stashed in a leather pouch sitting on the passenger seat right next to Forrest. The drugs, especially the fentanyl, are a big problem for Forrest. But the gun and ammo are a huge problem too, because the charge, carrying a concealed firearm by a convicted felon, could land Forrest in jail for up to 30 years if he's a habitual felony offender, or 30 years with a minimum mandatory sentence of 10 years in prison if he qualifies as a habitual violent felony offender. By the way, Forrest can also be sentenced up to 30 years with a minimum mandatory term of 25 years in prison on the fentanyl charge. Serious stuff, but this video is about the gun charge, so let's talk about that. Detective Getty swore the leather pouch was unzipped, but his body cam footage showed that the leather bag was zipped shut. In a search incident to a lawful arrest, or a search based on a drug dogs alert, the police can search closed containers in a car. So whether the pouch was zipped shut or not isn't important. However, the inconsistency between what Getty swore he saw and what the body cam footage showed could have created an issue with Getty's credibility in court. So Getty seizes everything in the car, including the pouch, gun, and ammo, and he sends the gun off to the police lab so they can check to see if Forrest's DNA is on it. The lab finds the DNA of two guys, and the lab says one of the contributors could be Forrest. Sounds like the prosecution has a strong case, right? I mean, there's nobody in the car but Forrest. There's a pouch with a gun in the car right next to Forrest. Forrest had access to and control over the pouch. Forrest is a convicted felon, and his DNA is on the gun. The thing about it is, though, when it comes to the law, very few things are just simply black and white. Though Forrest couldn't be excluded as a possible contributor to the mixed DNA, there was no evidence showing when Forrest's DNA ended up on the gun, who put the gun in the pouch, when the gun was put in the pouch, when the pouch was put in the car, who put the pouch in the car, and whether Forrest even knew the gun was in the pouch. Forrest didn't make any statements regarding the gun. Getty didn't see him holding the gun, and the gun wasn't found on Forrest. Under these circumstances, the prosecution has to prove when Forrest touched the gun. Did he touch it before or after he was a convicted felon? Because if it was before, he can't be charged with or convicted of being a felon in possession of a firearm. So now let's take a look at the law. Possession of a firearm may be actual or constructive. Actual possession means the object is in the hand of or on the defendant, or the object is in a container in the hand of or on the defendant. There also has to be evidence that the defendant knew or should have known of the illegal nature of the object. Where the state has no evidence that a firearm was found on the defendant, it then has to present evidence proving constructive possession. So let's talk about constructive possession in a purely circumstantial case, which is what this case was. Constructive possession requires the state to prove that the defendant had knowledge of the presence of the gun and the ability to exercise what's called dominion and control over it. Constructive possession exists where someone doesn't physically have the gun, but he knows it's near him and he has the ability to exercise dominion and control over it. In other words, he can grab it if he wants to. A gun found in an area over which the defendant had exclusive possession can establish knowledge, dominion, and control, and hence constructive possession of it. So maybe you're thinking, no problem proving Forrest had dominion and control over the pouch because it was right next to Forrest on the passenger seat. Yet there's a problem with that. There's no evidence of Forrest's fingerprints or DNA on the pouch. So who put the pouch in the car? No way to tell. And what about the gun inside the pouch? Like, how can you prove Forrest knew there was a gun inside the pouch? You can't. But there was a gun in the pouch next to Forrest, and the gun had Forrest DNA on it. Shouldn't that be a problem for Forrest? No, no, no. Why? It all has to do with the limitations of DNA evidence. So let's talk about that. A defendant's fingerprints or DNA alone can't prove a purely circumstantial case because a special standard of review applies. The special standard requires that the circumstances lead to a reasonable and moral certainty that the accused and no one else committed the offense charged. It's not sufficient that the facts create a strong probability of and are consistent with guilt. They have to be inconsistent with innocence. For instance, fingerprints alone found on items in a murder victim's home are insufficient to establish the defendant's involvement in the murder. The fingerprints or DNA alone don't establish anything other than the fact the defendant touched the items before or after the murder. The evidence doesn't show anything else, especially that the defendant had anything to do with the murder. The DNA can't talk in Forrest's case and say, hey, Forrest put me here an hour ago, a year after he was convicted of that felony. All the DNA can say is, I'm here. Without more, there's no telling when the DNA got there. This principle is illustrated further by the famous fingerprint on the potato chip can. A defendant's fingerprint, or for that matter, DNA, on a potato chip can that a marijuana plant is growing in doesn't prove anything other than at some point in time the defendant touched the can. Big deal. The fingerprint does nothing to prove the defendant's possession of the plant because the fingerprint could have ended up on the can before the plant was in the can. The fingerprint alone doesn't exclude the reasonable hypothesis that there wasn't a plant in the can when the defendant touched it. The evidence is consistent with guilt, but most important, it's no less consistent with innocence, and that's the point. The same applies when someone's fingerprints or DNA are found on something along with the fingerprints or DNA of other persons. You can't say when the defendant touched the item. For example, a defendant's fingerprints on an envelope holding foil packets containing heroin can't establish the defendant's possession of the heroin because it's possible the defendant handled the envelope or the packets before the heroin was put inside. The point is, in a circumstantial case, the evidence of possession has to be inconsistent with every reasonable hypothesis of innocence. So let's analyze whether the evidence proved that Forrest possessed the gun. First, since there's no evidence the gun was on Forrest or in a container Forrest was holding, there's no evidence proving actual possession. So we can get rid of actual possession. But what about constructive possession? Evidence supports constructive possession of a firearm in plain view next to a defendant sitting in the driver's seat if the defendant knows of its presence and has the ability to control it. In Forrest's case, Forrest must have known there was a pouch right next to him in the passenger seat, and since the pouch was right next to Forrest, he had the ability to exercise dominion and control over it. However, since neither Forrest's fingerprints nor his DNA were on the pouch, the evidence doesn't establish that Forrest put the pouch in the car. Also, the simple presence of the pouch doesn't prove he knew about the gun in the pouch. What about his DNA on the gun? I don't know. What about it? It doesn't prove anything, other than at some point in time, Forrest touched the gun. There's no evidence when his DNA got on the gun. Therefore, the evidence doesn't exclude the reasonable hypothesis that Forrest's DNA ended up on the gun before he became a convicted felon. Since it's just as likely that Forrest touched the gun before he was a convicted felon, as it is that he touched the gun after he became a felon, there's no way to prove Forrest possessed the gun when he was a convicted felon. The additional fact that someone else's DNA was on the pistol doesn't help the prosecution's case because that makes it even more likely someone else touched the gun after Forrest became a convicted felon. As far as his knowing there was a gun in the pouch, even if the pouch was unzipped, there's no evidence Forrest could see the gun in the pouch. If he couldn't see the gun in the pouch, and there's no evidence Forrest ever touched the pouch, there's no fingerprints, DNA, witnesses, nothing, the evidence can't exclude the reasonable hypothesis that he didn't know about the gun. It's no different from a case where the defendant's possession of drugs in the box couldn't be proved because there was no evidence establishing when the defendant was in contact with the box or otherwise indicating they had knowledge of the presence of the drugs in the box. While the opposite of all this might also be true, what counts is when there's a reasonable hypothesis of innocence, no matter how strongly the evidence suggests Forrest is guilty, he can't be convicted. Even if you assume Forrest touched the gun, the problem is it's impossible to say when he touched it. Those are my thoughts on this very interesting situation. Feel free to comment on my video. Comments always generate interesting discussions. Subscribe to my channel, and if you're a lawyer, consider hiring me to research legal issues and draft pleadings under your supervision. My contact information is below. Thanks for watching, and I'll see you next time.